Welcome to a presentation regarding resisting an officer in Louisiana, presented by Carl Barkemeyer, attorney at law. What is the criminal charge of resisting an officer in Louisiana? Resisting an officer is the intentional interference with, opposition, or resistance to, or obstruction of an individual acting in his official capacity and authorized by law to make a lawful arrest, lawful detention, or seizure of property, or to serve any lawful process or court order when the offender knows or has reason to know that the person arresting, detaining, seizing property, or serving process is acting in his official capacity. Examples of resisting an officer in Louisiana may include flight by one sought to be arrested before the arresting officer can restrain him and after notice is given that he is under arrest, any violence toward or any resistance or opposition to the arresting officer after the arrested party is actually placed under arrest and before he is incarcerated in jail, refusal by the arrested or detained party to give his name and make his identity known to the arresting or detaining officer, or providing false information regarding the identity of such party to the officer, congregation with others on a public street and refusal to move on when ordered by the officer. So what is an officer? The word officer, according to the statute, includes deputy sheriffs, municipal police officers, probation and parole officers, city marshals and deputies, and wildlife enforcement agents. The penalties for resisting an officer in Louisiana may include imprisonment for not more than 6 months, may include a $500 fine and possible court costs, and also a period of probation. The sentence is left up to the judge as to what the penalty will actually be. This information is not intended to be formal legal advice. If you've been charged with resisting an officer in Louisiana, I advise that you seek the assistance of an attorney.